today. My name is Attorney Judith Luce Montgomery of the Atlanta Family and Immigration Law Firm, and I have my special guest today, Employment Discrimination Attorney Brianna E. Williams, who is here with us today. She's going to be sharing with us some top 10 employment questions that she has been receiving. And then she's really going to impart on us some information just on what calls she's been getting in her office. Obviously, a lot of this area of law with COVID-19 is still developing, but we want to come and bring you the latest and greatest information as it develops. And so we will be answering questions live. So obviously, if you have any questions on Instagram or Facebook, please feel free to chime into the conversation, because that's just what this is, a conversation. So without further ado, Attorney Williams, if you can tell us a little bit about your firm, and we'll go from there.
Thank you so much, Judy. It is a delight to be here with you today.
Thank you for being with us.
Thank you. This is my first Facebook Live since this pandemic started, so I really appreciate this invitation to share all of this wonderful knowledge with people. This is a very developing area of our practice.
Yeah.
So, the more knowledge we have, the better all around, right?
Yes, indeed. Employment, we need that, especially as folks start going back to work in the midst of an ongoing pandemic. Yes. They need some answers.
Yes, and it seems like a lot of employers are in a rush to try to get back to work, and a lot of employees are also eager to get back to work. But we need to be smart about it, and we need to make sure that, we follow the guidelines and the regulations in doing so that we don't infringe on anybody's rights. So as an initial matter, my practice is primarily employment discrimination. So essentially, if an employee has been terminated based on a protected characteristic like their age, race, sex, national origin, religion, genetic information, color, or disability, I take a closer look at those cases and often will work with employees and employers to resolve those matters. Now, wrongful termination is a term of art. I mean, Georgia is an at-will state, and many states in our union are at-will states. So if you get terminated because your boss doesn't like you or because you get into an argument, sometimes you may not have a legal issue. But I definitely like to look at those issues and help when it's appropriate and when I can. And so, again, this is a very developing area of the law, but it's fascinating. It's really fascinating to see how we react in times of stress, because, boy, I tell you, I've seen a lot of things in my practice that really take my breath away.
So with that being said, before we get into some of the questions that were sent in, if you can share with us or shed some light on some of the things that you're seeing in the last 90 days since this pandemic has hit the United States. What are you seeing?
Well, unfortunately, a lot of what I'm seeing is employers using this pandemic as a legitimate non-discriminatory reason, and I'll put that in quotation marks, to terminate employees who may be in protected classes. A lot of employers I'm seeing are using this as a loophole to get rid of folks based on protected characteristics or to retaliate against people. And it's very concerning. Now, obviously, that's not always the case. And I always like to give employees and employers the benefit of the doubt. But I am definitely seeing some cases wherein a person, indicated, hey, I feel like you treated me differently because of my race, or because I'm older, or because I requested an accommodation last week, or, because I'm Muslim. And now all of a sudden, miraculously, we need to let you go because of the coronavirus, but we're not going to let go of the other people who are similarly situated as you, but outside of the protected class. That concerns me. And those types of matters have been popping up on my radar quite a bit lately.
Wow.
Yeah.
Okay. All right. Well, let's start with the first question that we received. It says, I was furloughed in March by my employer and I am over 55 and have diabetes. Do I have to go back to work or can I continue to get unemployment? Is this person in a protected class?
It really depends. Certainly, individuals over 40 are in a protected class, and individuals who have disabilities are in a protected class. And so, to the extent that person, has diabetes, and that diabetes presents itself as a disability, and those are decided on a case-by-case type of basis, it really depends. The question that I would ask this potential client is, what were you doing before you were furloughed? At 55 years old with diabetes, were you able to perform the essential functions of your job? Were you receiving a reasonable accommodation? With respect to the first question, if that person was able to perform the essential functions of their job at over 55 and with diabetes, and they can continue to perform the essential functions of their job once their state reopens, then yes, they do need to go back to work if their employer invites them back to work. It's my understanding that if you are furloughed and your employer invites you to come back to work, that you cannot continue to collect unemployment under most circumstances. Now, there are exceptions, and those are decided on a case-by-case basis. But generally, my question would be, what were you doing before this? And how does this impact your ability to do your job?
Okay. Wow. So folks got to go back to work is what it sounds like you're saying.
Well, I mean, yes, we all need to go back to work at some point. But again, this is a case-by-case type of situation.
Right.
And so, I can't get on here and make a blanket statement that if your employer opens up today, you have to go to work tomorrow. Everybody has different circumstances that impact their ability to go back to work. And the government has put in place some safeguards to protect individuals who may have challenges as they try to go back to work. Those safeguards don't last forever. And so that's kind of what we need to impart to folks.
Okay. So I wanted to say hi to Jim_go2 on Instagram and the King Plan on Instagram that has joined us before I go on to our next question. Okay. The second question is, now that my employment is now open and I have to go back to work, but my kids are still out of school and daycares are not open, can I stay home and take care of my kids and not lose my job?
Okay, that's a very good question. And a lot of people are faced with this challenge today. A lot of people.
A lot.
The answer is, again, it depends. Okay. Under the the Families First Coronavirus Response Act, and also the CARES Act, there are some safeguards in place to protect individuals who have to take care of their children when their schools and daycares aren't open. But again, those safeguards don't last forever. And under certain circumstances, depending on the employer size, like small businesses, for example, some businesses are exempt from those protections. And so really, I think if you are in a situation where you're being asked to go back to work and you don't have childcare, you need to take a look. Number one, is my employer over 50 employees? Okay. And if so, is that employer covered by the Families First Coronavirus Response Act and/or the CARES Act? Different acts, and I'm still educating myself on those acts. And if so, you may have some access to emergency paid sick time. 80 hours if you're a full-time worker, and if you're a part-time worker, it is the amount of times and earnings you normally work in a 2-week period. So you may have some emergency paid sick time. You may also have some emergency paid family leave if you've been employed by your employer for at least 30 days. In some cases, you may be entitled up to 12 weeks of emergency paid family leave. But that's only if your child's school or place of care is closed or child care is unavailable due to coronavirus. So if the daycare is open or if school is open, you may just be out of luck. So again, this is on a case-by-case basis. These are developing issues. We're all keeping an eye on them. But again, this is the challenge that we're all faced with. Now, that said, if you decide to take leave under this act, I would really, really encourage that individual to provide proper notice and to do it in writing.
Always. That's right.
Clients all the time. If it's not in writing, it didn't exist.
It didn't happen.
It didn't happen. And so many people say, oh, but I told him that I felt I was being treated differently because I'm Black or because I'm Muslim or because I'm 60. And my first question is, well, did you send an email? Did you write it down? Oh, I was too scared to do that. I wasn't so sure about that. No. You want to put this in writing, okay? And there are limits on how much your employer has to pay you under these regulations. This isn't a free-for-all. This doesn't last forever. So definitely put your request in writing. Don't be surprised if your employer is not covered if it's a small business. And be smart.
Yeah, that's right. I just wanted to say hi to Mocha Glam on Instagram. Thank you for joining us. Going on to the next question. Can my employer retaliate against me for asking for leave under new CARES Act?
The answer is no.
Okay.
However, these cases are popping up almost daily across the country. And I don't believe any of these cases have been decided yet. So no, your employer cannot retaliate against you for asking for leave under the CARES Act. But what is the penalty? And how do we go about proving that? Those are still very developing questions.
Okay.
So, again, I just kind of have to be broad with that one.
All right. And that's okay, because the thing is, when the questions are sent in, we want to address the questions the best that we can, but we also have to be honest and fair to the person that is speaking, because this is such a new act. I don't even think these acts are 100 days old, honestly.
No, they're not.
We don't have all the answers. A lot of times people expect us to, but as attorneys, we're watching this thing unfold just like you are. I don't know how many other folks have gone through a pandemic, but this is a first for me. How about you?
1918, thank you. I mean, I'm older, but I'm not that old.
You're funny. I know. When was the last one you said? 18? When was it?
The Spanish flu, right? Wasn't that the last one? Oh, no. I think there was the H1N1 or the SARS and Ebola and all that, but I mean, they weren't.
Okay. I don't know if it rose to this level, but okay.
No.
Got it.
I'm aware.
All right, then. Number 4, Jim is laughing. Number 4, can my employer cut my pay if I ask for leave? Because I just don't feel safe sending my kids to daycare right now.
Okay, again, that is another maybe case-by-case situation.
Right.
There's really guidance on this across the board. And, if you fall into a high-risk category, or if your child falls into a high-risk category, you may have different protections than someone who's not. Or if you are a healthcare worker, the regulations that you go by are different than someone who's not a healthcare worker.
Right.
So the answer is maybe. But again, even if you get coverage under the CARES Act, that 80 hours of emergency paid sick time or the 12 weeks of emergency paid family leave, depending on how you're exposed to this, that doesn't last forever. So if the question is, can I stay home from work for the next 18 months, while they look for a vaccine? Right. I highly doubt that would be protected.
That's not going to happen. We realistically, I think they said that a vaccine is 18 months out. is what we're hearing.
I heard that.
And so, I'm self-employed, but I can assure you my employer isn't going to let me sit home for 18 months while we wait for a vaccine. So,
and I'm self-employed too.
We're going to have to get back into these courthouses, whether we like it or not, I see. But good to know. Safely, hopefully. That's right. Yes. So going on to the next question, I work for the airlines and they asked me to take a 25% pay cut, but continue to work. Is that even legal?
It is.
It is. Wow.
Minimum wage, you can certainly get a pay cut, and employers across the board are instituting pay cuts. I mean, look, be glad you got a pay cut, you still have a job, as opposed to being furloughed or terminated. So yeah, those pay cuts are legal.
Wow.
Don't like them, but they're legal. Again, case by case basis. If now I'll say this from my employment discrimination lawyer hat, okay, because that's primarily what I do. Okay, if all of the purple people get 25% pay cuts, but orange people don't get 25% pay cuts. They're all sales associates and they're all on the same team, then that would raise a red flag for me. And I would think that maybe the purple people are being treated differently than the orange people, and that may be something that could be protected under, Title VII. So there are different ways to look at these questions. There's not a one-size-fits-all answer for all of these.
All right. So the second part of that question is, but they won't approve unemployment for me. Can I still apply for unemployment? Will I be punished?
Yeah. So you should not be punished for applying for unemployment. And certainly, again, this is a state-by-state issue. But yes, if your hours have been reduced, you may be eligible to receive benefits if your gross earnings plus the earnings allowance do not exceed your weekly benefit amount. Now, again, this isn't really my bread and butter in terms of my everyday practice, that is unemployment. But from what I've researched on this issue, there are some instances where it's appropriate and perfectly fine to apply for unemployment if your pay has been cut or if your hours have been cut.
All right. Okay. And I just want you to know, this is, I would think that this information is so valuable in the midst of what is going on right now, because I see it pop up a lot and people will tag me on a post and I will, kindly have to remind them that I do not practice employment or unemployment or any of those types of law. Interestingly, though, I will tell you, I used to be an administrative hearing officer for the Georgia Department of Labor, holding unemployment hearings. So I used to hold 6 unemployment hearings a day. Yes.
Okay. Yes. I tell my clients, when they start getting off the beaten track and asking me all these questions I don't know the answer to, I say, look, would you want your cardiologist to deliver your baby?
Correct.
Of course, the answer is always no. So, I don't know everything. I may look like I know it all, but I really don't.
Right. That's correct. But I will get you in contact with the person that I believe has the answer to your question.
Yeah, we have a strong network of lawyers. Yeah. Between me and you and all of our colleagues, I'm sure we can get everybody with most questions answered.
Definitely. So question number 6, I have been getting unemployment since I was laid off. Can I wait until the 8 weeks is complete to get all my unemployment, then return to work because I make more money on unemployment?
This is my favorite question, right?
Right.
I mean, you know what? The sad part about this whole pandemic is that it has revealed so much income disparagement and inequality among the workforce, okay? And so many of our gig workers, self-employed, service industry workers, so many of us are receiving more in unemployment than we do just to perform our everyday job. And
Right.
that is raising all kinds of other questions and all kinds of other issues that I'm sure will be written about for years and years and years to come.
I don't know if you heard about, there was an article about a nail salon owner who had applied for the, I think it's the payroll protection loans, and she received them and was approved. So she was able to continue to pay her staff, and her staff was livid.
Of course.
Because they were like, we're making more money on unemployment. We would rather continue to get unemployment than for her to pay us our our wages. And so people were like, well, she may need a criminal attorney if they try to attack her.
Yeah, so people are having trouble spending that PPP money because a lot of folks just want to stay unemployed. I mean, I can tell you with that extra $600 a week bump that the federal government is giving out until June or July, I believe it's July.
Yeah, I think so.
$400 a month.
Yeah,
that's more than what a lot of people make per year.
Wow.
So I can see many, many people not wanting to take that money under the Payroll Protection Act and continue to stay on unemployment. But again, this is a case-by-case situation. Some people may be able to say, look, I have coronavirus, or, my daughter has coronavirus and I need to stay home to care for her. I'm not able to come to work right now.
Right.
And some other people may actually be able to come to work, but don't want to come to work because, it's cheaper to be on unemployment. So the technically correct answer is it's on a case-by-case basis, but you're not really supposed to, not go to work if you're given the opportunity to work, right, so that you can collect that federal $2,400 a month. Okay, that's the bottom line.
That you can't be mad at them though. You can't be mad at them.
I can't be mad, but it's not right.
Yes. So Tracy on Facebook said that she totally agrees. So Tracy's joining us. Thank you so much.
Yes, Tracy is actually an attorney as well. She's also a nurse. She should have been on this live because she's got a totally different perspective as well. So I'm glad to see Tracy on this.
So you said Tracy, she's also a nurse?
She is also a nurse. Yes.
Ooh, I need to talk to Tracy. We're going to have to get Tracy on here to talk to the people about what's really going on. Yeah. Is she back in the hospital during this time?
I do not believe she is. I actually believe that doing some health law, and she's also helping employees with OSHA matters. I mean, because that's a totally new thing that we're seeing, a lot of safety issues coming up in the workplace and OSHA violations and folks just not being safe about, how to manage the return to work and it causing problems.
And that's interesting because one of our questions coming up references that. So Tracy, if you'll chime in, we would love that. So the next question is from an employer. Can we ask staff to return to work if they can continue to work from home?
Yes, you can. You certainly can ask them to return to work if they can work from home. And, again, you may have the type of job that requires folk to be in the office a lot of times, face-to-face interaction, team building, those types of things. You can ask them to return to work. Now, whether they will or not is remains to be seen. And again, that's on a case-by-case situation. So if you've got, someone who has who is immunocompromised, okay, and they're working from home, and you ask them to return to work, and they say, look, I can't return to work right now because I am immunocompromised and I do not believe it is safe. Well, I think that situation would probably be treated differently than somebody who, is at home, perfectly healthy, perfectly able to work, and just doesn't want to come to work because it's easier to work from home.
Okay. So Tracy has a question for you.
Mhm.
She says, can you address the privacy issues that employers will address regarding the health status of their employees? How do you inform employees that they may have been exposed to COVID-19?
That's a great question, Tracy. And the EEOC has put out some guidelines on that. For many people believe that, because of HIPAA and, not, being able to disclose medically protected information, that may somehow tie an employer's hands. But certainly, other employees have the right to know if one of their colleagues has been exposed to the virus or has the virus. Employers can certainly take the temperatures of the workforce and can certainly put things in place to protect its workforce, in accordance with CDC guidelines. And, also the Georgia Department of Labor, I believe, has put out some guidelines as well. In the Centers for Disease, the Centers for Disease.
CDC, yes.
That's what I meant to say, not the Department of Labor. And so there are going to be some privacy issues. But I believe that the pandemic is really shining a light on the fact that employers also need to take into account the greater good of the workforce and to, promptly inform employees if there is a possibility that they may have been exposed to someone in the workplace who either had the virus or was also maybe exposed to someone with the virus. So again, this is going to open up a whole new can of worms. It's a developing issue. The EEOC's put out some great guidelines. That's all I got to say about that one.
All right, we'll move on to the next. This is from an employer.
Okay.
So Tracy, please jump on if you can and tell us what your thoughts are. So this says, what steps do we have to take to make sure we are COVID secure? And do we have to provide PPE for employees? What are your thoughts on that?
Well, I don't know that an employer could take all the steps to be COVID secure. I mean, I'm certainly not the person to give that advice. However, as an initial matter, I would highly recommend that they stay up to date and make sure they're getting reliable information from the Centers for Disease Control and the Department of Public Health. The Department of Public Health has already put out some guidelines recommending that employers and employees use teleworking, to the greatest extent possible right now.
Right.
To consider staggering their work schedules, to consider canceling non-essential travel, to maybe hold meetings virtually. I mean, how many meetings have we gone to that could have been emails or phone calls?
How many hearings have we attended that could have been Zoom hearings? Is my question.
Actually changing the face of our profession.
That is the hope. Brianna, that is the hope. And a lot of attorneys have kind of been, whispering loudly because we are already getting court notices for June to be back in a courthouse. And so a lot of attorneys are feeling very uneasy about that, especially when these hearings can continue to be Zoom, because I feel that it's been very effective and I've been very efficient with these Zoom hearings. So on that note, and I did tell you that I was going to ask you my own question, even though I am my own boss, do I have to go back into the courthouse before I feel comfortable, or can I stay home? What are your thoughts?
Your clients employ, your clients, basically employ you, but you're the employer. You're the one who writes your own paychecks. And so I would suggest that you do that at your, on a case-by-case basis. I'm a hearing officer for DeKalb County. And, the next time we have an administrative hearing, I will be there with a mask on, or to the extent we can do it in Zoom, we will do it that way. I'm also a mediator, same thing. To the extent we can do it on Zoom, let's do it that way.
That's right.
But, again, if it's a situation where you absolutely have to go in, or else, you're not advocating on your client's behalf, then that's a conversation you need to have with your client. And to the extent you feel and your client feel it absolutely necessary for you to go, then you should take the precautions you feel appropriate to make sure that you're comfortable. Wear a mask, engage in social distancing.
Right.
I feel like people don't really appreciate what social distancing is. I mean, 6 feet is,
No.
6 feet. Like, give me some space.
They don't. They don't. Not at all. Let me ask you this question.
Hmm.
If one employee coughs on another employee and an employee gets COVID-like symptoms, can the employer be held liable? And obviously, you may not have the answer to this question. And can the employer insulate and protect themselves by having all the employees sign a waiver?
So for the first part of that question, I think as time goes on, it gets harder and harder and harder to prove that an employee got coronavirus in a specific place. This virus has spread like wildfire. I told my kids the other day, if somebody coughs on me, I'm going to be, whoa, hold up. Okay?
Right.
But if, for some unfortunate reason, I end up with coronavirus, the question is, can I now sue my employer because somebody coughed on me? I don't know. We actually had that bus driver who was on Facebook Live when this first thing started. Did you see him?
I did. And he passed away, if I'm not mistaken.
Died a few days after that Facebook Live after complaining that somebody was coughing on him on the bus. And to the extent his state, sues, one of the questions is going to be, how do you know that he got the coronavirus while he was driving the bus?
The job.
Yeah.
It, because you go to grocery stores, there's people that live in your home, you don't know where they've been. It can be contracted anywhere, anyhow.
Let my home have been. I know where they've been.
That's true. So still developing area, we're still trying to figure that out, right?
Definitely.
Gotcha.
Use common sense. In terms of the waiver, I'm seeing a lot of that. A lot of my colleagues are drafting waivers for their employer clients to sign. And, we're going to see a lot of that. Now, first of all, liability waivers are very limited, okay? And to the extent a waiver contravenes public policy, sometimes courts won't enforce those waivers.
That's right.
And so that's something you need to talk to your insurance company about. That's something you need to speak with your lawyer about. And to the extent you need to, make sure that you're following all the guidelines. I mean, because again, if you make certain assertions in your waiver as to things that you're doing as an employer to protect employees, and you slip one day and your employee sues you for it, then what happens to your waiver? Can you still enforce the waiver? I think those are some very interesting questions that we're going to be seeing in the coming months and years, because I think this is just the beginning.
Well, and that goes into our next question. Can an employee refuse to work without a mask?
Yes. So, OSHA has actually addressed this issue.
Okay.
And certainly an employee can refuse to work without a mask. But again, there are, this is a case-by-case situation, okay? So according to what I saw on, with respect to this question, an employee's right to refuse to do a task is protected if all of the conditions are met. The first one being, where possible, you have asked the employer to eliminate the danger and the employer failed to do so. I mean, that's loaded. What does it mean to eliminate the danger?
Right.
That's a big question that courts are going to be deciding. Number two, you refuse to work in good faith. That means that you must genuinely believe that an imminent danger exists. What does it mean to genuinely believe that an imminent danger exists if coronavirus is all over the place?
Correct.
Number three, a reasonable person would agree that there's a real danger of death or serious injury. Well, yeah, I mean, I think a lot of us, depending on our comfort level and our own health status, believe that, certain areas are safer than others when it comes to this pandemic. And then the fourth one is there isn't enough time due to the urgency of the hazard to get it corrected through regular enforcement channels, such as requesting an OSHA inspection. So again, I think that's kind of a case-by-case situation. I think that this will be interpreted by the courts. If I sat up here and told you that I knew the answer to all of these and it was just, 100% lockdown, this is what it is, I would be misleading you. But these are certainly things that we're going to be seeing coming up, very soon in the court system. I mean, some of them are already going through. Need to keep an eye on them. But bottom line, be safe.
Be safe.
Be safe.
That's it. There you go. And so we're coming up on our last.
And document. Document. Write it down. If it isn't written, it doesn't exist. And, I think it's amusing when people come to me and say, but girl, I got everything on recording. I recorded everything. And I'm like, okay. Did you write it down? Did you send an email? I mean, come on, Exhibit A. I told my employer that this was not safe. I didn't feel safe. I'm immunocompromised. And, this individual just really made me fear for my health. And this employer still, insisted that I do something that made me uncomfortable with respect to this pandemic. I mean, put the stuff in writing.
Wow. There was so much good information, but we have one more question. So I want to squeeze it in. I know we're over time, but I just want to squeeze it in. Can we instead offer informal entertainment areas or kid zones for employees' children who are not allowed to go to school? That's a great question. Great question. Can you answer that for us?
No, I would not recommend that for employers. I would not recommend that because, again, we have all of these other unanswered questions in terms of, can an employer get sued for,
True.
getting COVID-19 at work? Okay.
Right.
And is there a premises liability issue if a child comes on the premises and gets COVID-19 because they were in the entertainment area or kid zone? So I wouldn't recommend that. But again, I know that these are trying times and that, people are trying to be creative in terms of how they work through these situations. Again, my bottom line is be safe, don't retaliate. Treat everybody fairly. Don't discriminate against individuals based on, their status, based on their protected characteristic, and be smart about this. And if we can just work together, we can get through this.
Awesome. Attorney Williams, thank you so much for joining us today and imparting your wisdom and providing us with all this necessary information. I hope that everyone appreciates it and is able to share it as much as possible for those who still have questions. And obviously, Attorney Williams, we want you to provide your information. Where can they find you if they have additional questions or they believe that they have been discriminated against in their employment situation?
Absolutely. You can definitely call my office. My office number is 404-793-7993. Call my office. Let me know what your question is. I may be able to assist. I have a website that I need to update. I'll be doing that during my pandemic downtime, but I haven't had too much downtime. At the melangefirm.com, TheMelangefirm.com. And my email address is Brianna, Brianna, @themelangefirm.com. So that's pretty much what you need to know about me. I'm pretty accessible, and I'm happy to assist in any way that I can.
I appreciate it. Thank you so much for your time. Tracy, thank you so much. And we will be chatting soon. And Jim held on with us all the way to the end. So we always appreciate Jim joining us on Instagram Live. And so, guys, this is Attorney Judith DeLuce Montgomery of the Atlanta Family and Immigration Law Firm. You can find me on the World Wide Web. It is scrolling across the bottom. The phone number is 678-601-5580. Nous parlons Creole and habla Español. So until next week, guys, thank you so much for joining us.
Thank you for having me.
Thank you.